appeal in the matter of Kuwait Oil Company, Al Tarkait.
Yes, Mr. Duggan.
May it please your lordship, my ladies. My lord, the claimant is not here today and is not represented. As far as we know, he's still in Kuwait and has played no recent part in these proceedings.
Yes.
It's therefore for me to open this appeal. And can I just check that your lordship has the bundle of documents? It's really the primary document is tab 5, the decision of judgment of Mr. Justice Kerr.
Yes.
I do also have spare copies of the judgment of Employment Judge Taylor if they are required, but the relevant passage is in fact in the judgment of Mr. Justice Kerr, so it's possible that we won't need to look at that decision.
Well, I got a copy of it.
Yes.
I printed one off, so I have it.
20th and 21st of August,
Yeah.
2018. Yes.
But my lord,
Got
the
it.
two paragraphs that are relevant are in the Employment Appeals Tribunal
Yes.
judgment, as I said, so I don't think it's really necessary to refer to them. My lord, it's a short point in relation to the construction of the tribunal procedure rules in relation to costs. And this case was in fact a very long-running case before the Employment Tribunal. It was subject to one adjournment where the case was literally about to be heard, and we had 4 days into the tribunal. Then Employment Judge Auerbach took the view that it was necessary to adjourn the case. It was adjourned over and eventually heard by a full tribunal with Employment Judge Taylor as the employment judge. The claimant was claiming some £7.5 million by way of disability discrimination, in addition to an unfair dismissal claim. And it was effectively conceded that the dismissal was unfair because Kuwaiti procedures had been followed as opposed to English procedures. The result of that was that the claimant was awarded the full amount of compensation on the basis he had a substantial salary, and although there was a Polky finding that the claimant could have been dismissed within 3 months, it still took him to the cap on compensation.
But the tribunal made reductions both for Polky and Contrib.
My lady, yes. And
It's
even
simply that there was a very high level of earnings, so
my
that
lady, yes. The level of earnings when one added on all of the benefits was something like £750,000 a year. So even with the deductions, the claimant received the maximum amount, or was awarded the maximum amount. There was also a costs order in favour of the claimant, and my lord, you will have seen that the costs are approximately £4,900 in relation to the claimant's costs. The reason that I outline this first is that when those sums are added together, on the face of it, the claimant would have been due some £84,624.20, and that, I think, appears in Mr. Justice Kerr's judgment. The respondents, the appellants to this appeal, on the other hand, had a costs order in its favour in relation to very substantial matters where the claimant went on a frolic of his own and put in voluminous evidence which had to be dealt with, and in due course much of the evidence was struck out, and some of the evidence that was accepted to be struck out was withdrawn. The slight wrinkle in the case is that the Taylor Tribunal expressed concern about the level of costs which was being posited by the appellant for that exercise.
they said they weren't reasonably incurred. The historic allegations hadn't required that level of cost to be incurred.
My lady, yes. And the difficulty with that is, of course, the tribunal was not taken to the detail of the costs or the reasons for them. It was, if I may put it this way, a knee-jerk reaction from the tribunal to what they thought was a level of cost. Because it was in excess of £200,000, it was excessive. What the tribunal didn't take on board was the fact that the client was in Kuwait and that most of the witnesses did not speak English particularly well.
Well, Mr. Duggan, we're not concerned with as it were, the question of how much costs were reasonably incurred. I'm sure you've got a tale to tell on that, but it's not a matter for us, is it? We're simply concerned with the jurisdiction point.
My lord, no, my lord. It is. I accept by way of background, but
yes.
I will take you in a second to what Employment Judge Taylor said in fixing the cap that he fixed on costs and why he did so.
Yes.
But the point
I see that. But forgive me for interrupting you. I'm not up to speed on this. Judge Taylor repeatedly refers to the Auerbach Tribunal, and I see from the chronology that there was what was described as a merits hearing before the Auerbach Tribunal, 4 days, in which KOC applies for a postponement, and then 13th January, judgment of the Auerbach Tribunal in which various case management orders are made. Is that what was listed as the merits hearing turned into a rather substantial case management?
It was in fact listed for longer than 4 days, and I think it was listed for 7 days at that time. The claimant served a witness statement that contained numerous additional matters, and the Auerbach Tribunal looked at those additional matters first. That took up something like a day of the tribunal's time. The claimant then realised that part of the pleading was incorrect and sought to amend to change a date, and on the basis of, and I don't need to go into the detail, my lord, but on the basis of that change, the Auerbach Tribunal took the view there was no other alternative than to adjourn the case, make case management orders. There was an application for disclosure by the claimant in relation to some documents, which the claimant was partially successful on, and that, hence the £4,900 costs order. So as matters stood after the Auerbach Tribunal, there were effectively going to be arguments about costs in relation to the disclosure by the respondent, the necessity for the adjournment, and the additional matters that the claimant had put forward. And it was in relation to the first and third matters that Employment Judge Taylor made orders.
Right.
So he refused to make any orders in relation to the merits of the case, but made orders in favour of the claimant in relation to the disclosure matter and in favour of the respondent in relation to all the matters that were struck out.
Yes.
And, my lord, with it in mind that, as you have pointed out, this court isn't going to be looking at the level of costs. Perhaps if I could take you to the judgment of Mr. Justice Kerr, which is at tab 5 of the core bundle.
Yes.
And the passage that I would respectfully first take you to is paragraph 35, page 35 at the bottom.
Yes.
And you see in paragraph 35, the learned judge sets out the findings of the Taylor Tribunal in relation to costs, the way in which Employment Judge Taylor approached costs. In paragraph 34 of the tribunal decision, you see, my lord, what the Taylor Tribunal said was that we limit the costs awarded to the respondent to the sum of compensation awarded to the claimant and the costs awarded to the claimant. We do this on 2 grounds. The most important reason we make this decision, irrespective of our second ground, is because we do not see how the respondent should, acting reasonably, have incurred any costs in excess of that sum in dealing with the additional obligations. And of course that sum is the £84,000 odd that I outlined earlier. While we accept that they were entitled to take steps to have the background allegations removed and carry out reasonable investigations into rebuttal evidence, they at most were background allegations. We consider that the amount of costs incurred in dealing with this matter was way out of proportion. While we accept these costs were incurred, we consider that the costs awarded should be limited to that amount as a reasonable estimate of costs that could reasonably be incurred in dealing with this issue. So the Employment Tribunal's first ground was that on the basis that this tribunal, the Taylor Tribunal, considered the costs to be excessive. It limited those costs to the full compensatory award for unfair dismissal plus the claimant's potential costs of £4,900. And then, in addition, it stated, in addition, taking account of the claimant's financial resources as we are entitled to, pursuant to Rule 84 of the Employment Tribunal Rules 2013, we consider that is a reasonable level which to set costs. So the two grounds on which the Taylor Tribunal limited costs were, one, they thought the costs were excessive, and two, because of the claimant's means. And, my Lord, what we say is that with respect to the tribunal, the plain reading of the procedure rules means that the tribunal was not in a position to effectively fix a cap on costs. Of course, at this point in time, we don't know what the assessed costs will be of the appellant, nor for that matter the assessed costs of the claimant. But the effect of that ruling of the tribunal is that no matter what costs are awarded to the appellant, they will be limited to the unfair dismissal compensation and the claimant's costs, and the two will effectively cancel each other out.
Yes.
We say that that is not what the rules provide for, and on the basis of this being a case that should go to an assessment, the learned employment judge should simply have sent this matter for assessment by an employment tribunal or by the county court and not have imposed that cap. Now, my Lord, it's probably helpful before one looks at the judgment further to consider what the rules in fact say. And they are set out in the authorities bundle, tab 3.
Mr. Duggan, before we do that, I'm so sorry. I just want to be clear. Your appeal is based on a contention that the tribunal had no jurisdiction. You haven't appealed the discretionary exercise of judgment made by the Taylor Tribunal, that was a reasonable estimate of costs.
My lady, the original appeal notice included that as a ground of appeal, but His Honour Judge Barklam refused to allow that to go forward on the SIFT, so I'm
and that hasn't been
I can't
It really it is
just a jurisdiction.
It's a pure jurisdiction
Yes.
point. So let's look at Rule 78.
So, my Lord, on that basis, I would ask your Lordship to consider the rules which, as I said, are in tab 3 of the authorities bundle.
It's also set out, isn't it, in paragraph 38 of Mr. Justice Carr's judgment?
My lady, yes. I'm happy to deal with it if it's easier to.
I'm doing it from the handbook because I find it easier to read. But anyway, hopefully it's the same rule.
It's the same rule, Mr. Lord. The provision of Rule 78 sets out different alternatives that can be adopted in relation to costs or orders by way of alternatives to parties dependent upon adjournments, etc. But the two provisions that we in particular have in mind that need to be considered together are 78.1a and 78.1b. Under 78.1a, it's provided that a tribunal may make a costs order that the paying party is to pay the receiving party a specified amount not exceeding £20,000 in respect of the costs of the receiving party. So it's a specific amount of compensation by way of costs that can be made. The tribunal will specify the precise amount where the figure is under £20,000. Then under 78.1b, the alternative is that the tribunal may order the paying party to pay the receiving party the whole or a specified part of the costs of the receiving party. So in this case, we say what the tribunal has done is order that the claimant pay the costs of the matters relating to what was struck out. That was a specified part of the costs of the receiving party. And then the provision says, with the amount to be paid being determined in England and Wales by way of detailed assessment, either by a county court judge or by an employment judge. And we say, with respect, there is no power within 78(1)(b) for a tribunal to place a cap on costs, because on the plain wording of paragraph 78(1)(b), what the tribunal can do is specify that the whole of the costs should be paid, or a specified part of the costs, in that a specified part relating to the litigation can be paid, but not the amount of costs, because that is to be determined by the assessor. And we say, with respect to Employment Judge Taylor, that in deciding that the costs would be limited to the full compensatory award and the claimant's limited costs when assessed, that placed a cap on the appellant's right to have costs assessed, which the rules don't provide for. It's a simple, straightforward point of construction in our respectful submission. We accept entirely that submission creates some oddities when it comes to the procedural aspect of this. So, for example, it was accepted before Mr. Justice Kerr that if the matter was assessed by an employment judge, on the face of it, the employment judge, in assessing costs, could take into account the means of the party, because we go 2 pages further on in the
84
rules. Rule 84 provides that in deciding whether to make a cost preparation time or wasted costs order, and then the important words, and if so, in what amount, the tribunal may have regard to the paying parties, or where a wasted costs order is made, the representative's ability to pay. And we would accept that that gives the tribunal assessor a jurisdiction to take into account the means of the paying party when assessing. The reason that I say that it creates an oddity, or a lacuna perhaps, is that there is no similar provision if the matter is sent to the county court, so that it's the county court judge that, or costs judge, that assesses the relevant costs. And what I say about that, my lord, is that just because there is a gap in the rules doesn't mean to say that the submission that there is no power to impose a cap is wrong. The reality is that there is perhaps a lacuna in the rules that shouldn't be there, so that there should be a provision that the county court may have regard to the claimants, to the paying party's means. But the fact that there is this discrepancy in the rules doesn't alter the wording of Regulation 78(1)(b), which is clear on its face in my respectful submission. The amount to be paid is to be determined by way of detailed assessment by the employment judge. If we are correct on that straightforward question about the construction of the rule, it would mean that Employment Judge Taylor was not able to place the cap on the costs that he did, and that what he should have done is simply ordered that the matter go to an assessment. Of course, the assessor would have in mind, to some degree, the comments of the tribunal that had heard the case on the merits, and that would be taken into account in considering what was reasonable.
Well, suppose you're right. If you are right about jurisdiction, seems to me the case would have to be sent back to the tribunal, preferably Judge Taylor, even though he's now more exalted. But anyway, Judge Taylor and the same members, if practicable, to make a fresh order, because you would be saying that this is an order that they had no jurisdiction to make. We can't possibly say substitute, even if you're right about jurisdiction, an order that the respondent should pay the whole of the costs, subject to an assessment by somebody of what's reasonable in line with CPR 44.4.
Lord, I have to accept that the way that this court should have approached the matter is to first of all consider whether Employment Judge Taylor was incorrect and therefore there wasn't jurisdiction. If that is so, then the reality is that Employment Judge Taylor should simply have made an order that the costs as determined, i.e. as limited by the learned judge, should be assessed by an employment tribunal or by the county court, and your lordships could make that order. It does raise this rather difficult discrepancy, as I outlined, my lord. If it goes to the county court, the assessment would be under Section 71 of the County Court Act, and that does not provide that means are to be taken into account. There is provision, and it's set out in the Gilly judgment, to which I will take you in a moment. There's provision that the county court can order that costs be paid by way of instalments. But there's no provision for means to be taken into account. But of course,
They can't.
well,
Can they?
Lord, yes, of course, it's possible for the order to be that the matter is simply referred to the employment tribunal or to an employment tribunal to carry out an assessment. What we say in effect...
Who decides that? Can the tribunal specify that? Or is that not a matter for the parties to choose?
On the face of the rule, it would seem that it's a matter that the tribunal could specify, because it simply says that the amount to be paid to be determined in England and Wales by way of detailed assessment carried out either by county court or by an employment judge.
I know, but isn't it for the parties to choose to whom they refer for a detailed assessment, or are you saying it's for the tribunal to specify?
I would respectfully say it's for the tribunal to specify, because otherwise one faces this particular difficulty, which in fact is illustrated by this case. If there are costs orders in favour of one party and then other costs orders in favour of the other party, well, one party may say we want the employment tribunal, i.e. the claimant may say that because the claimant knows that means would be looked at, and the respondent says no, we want the county court because it knows that means won't be looked at. In those circumstances, it seems that it would be a matter of discretion on the part of the employment judge making the order as to where the matter should go. And Lord, I could put it this way: we don't have a difficulty with the costs being assessed. What my client objects to is the statement by Employment Judge Taylor that the costs were disproportionate, which we say usurps the position of the assessor, who can decide that.
But you're not entitled to run that. You've lost on that, and you can't appeal. That's Judge Taylor's assessment.
I accept I can't appeal on Judge Taylor's sentiment, but what
It's not a sentiment. He concluded, or they concluded, that the costs had not been reasonably incurred so far as the historic allegations were concerned, and that a reasonable estimate of those costs was £79,000 or 84, and you tried to appeal that, but you were refused permission.
But my lady, what we say is that if we were right on the interpretation of the rules, then that was something for the assessor to decide. That a statement made by Employment Judge Taylor that he considered the cost to be disproportionate can't usurp the position of the assessor, who was entitled to decide what costs were reasonable.
Why do you say it's usurping? Can we look again at the rule? Suppose, let's start with 78(1)(a). the tribunal may order the paying party to pay the receiving party a specified sum not exceeding £20,000. Right. If 78(1)(a) is used, there's no question of assessment by anybody except the tribunal. And if we go to 84, in deciding whether to make a costs order, and if so, in what amount, the tribunal may have regard to the paying party's ability to pay.
Yes.
Would you accept that if we were talking about 78(1)(a), the tribunal is entitled to form a view about the reasonableness of the receiving party's bill?
Yes.
Suppose it was a very standard one-day case where the claimant crashes in ruins and the tribunal comes to the view that the whole case should never have been presented, so brought to court, or the claimant has been guilty of unreasonable conduct, etc., etc. And the respondents produce a bill of £20,000, and the employment tribunal would be entitled, would it not, to say that this is an outrageous sum. We're not going to award £20,000. We're going to perform what in this building would be called a summary assessment, and you can have £10,000 or whatever. They would have jurisdiction to do that, wouldn't they?
Lord, yes.
I'm sure that's right. But once the case goes over £20,000, are they entitled to form their view about reasonableness and proportionality?
Lord, we say not. We say that once it goes over the £20,000 limit in 78(1)(a), the 78(1)(b) means that the tribunal could specify, whether by way of issues or whether there was a disclosure matter, for example, that the cost should be paid, it could specify in part that costs should be paid or the whole of the proceedings. But the amount must be determined, we say, by the assessor in those circumstances. And in reality, for example, taking your example, Lord, if the receiving party had incurred costs of, say, £40,000 and the tribunal took the view that £30,000 was reasonable, it would not be able to impose a cap based upon £30,000. We say it at that stage because that's for the assessor to consider what is reasonable.
Isn't the purpose of assessment of costs it's to scrutinise the winner's costs bill and possibly bring it down? That's but that's a different exercise, isn't it, from the question of, certainly a different issue from ability to pay, but it's also it's a different question from what it's reasonable to order the loser to pay.
Well, Lord, the difficulty with that proposition is that that's not the way the rule is structured. So that in effect what the Taylor Tribunal did was to cap the costs at £85,000, if I use that as a round figure.
Yes.
When in reality the costs were, we say, substantially more than that, 3 times more. But an assessor may decide that the reasonable costs were £100,000 or £150,000, or for that matter, £50,000. If it was below the £85,000, no difficulty. But if the assessor, having looked at everything, decided that reasonable costs in this particular case were, say, £90,000, that's what the rule provides the assessor is to do. by imposing a cap of 85,000, the Taylor Tribunal will have, in effect, fettered the assessor in terms of what can be ordered.
Well, let me just test it like this. Rule 84 is a general rule that applies to tribunals when deciding whether to make costs orders, and if so, in what amount. And it's
Yes.
well established that there are two stages at which the tribunal has to exercise a discretion. Should the costs order be made, and if so, in what amount? And Rule 84 allows ability to pay to be taken into account at both of those stages. On your argument, Rule 78(1)A enables the tribunal to take that into account, but not Rule 78(1)B. So we read Rule 84 as not applying to 78(1)B.
Milady, we say it doesn't apply if the assessment is carried out by the county court.
No, I'm asking about the stage at which the tribunal is deciding whether to make a costs order, and if so, in what amount. And on your argument, Rule 78(1)B excludes the Rule 84 permission to decide to take ability to pay into account.
Milady, yes, but in a slightly more nuanced way, we say, because what we say is that, first of all, the decision is whether or not to make a costs order in the first place, any costs order, at which point means is taken into account. The Taylor Tribunal decided to make a costs order, so that first part of 84 has been dealt with in the sense that the tribunal decided to make a costs order. Then it has to decide in what amount.
Yes.
Yes.
But what we say is that rule is subordinate to 78(1)B.
Why?
Why?
Because it's for where the amount in question exceeds £20,000, it's for the assessor to decide
Why?
the amount.
Why? Why can't the tribunal determining what amount to specify in relation to 78(1)B do what 84 permits it expressly to do, and take ability to pay into account at that stage?
Well, milady, it comes down to this. Does 84 apply generally so that 78(1)B is subject to 84?
Well, there's nothing on the face of it that suggests that it doesn't, Mr. Duggan. And the problem, speaking for myself with your construction, is that you could get a situation where a respondent who's won and has reasonably incurred a very large sum of money is up against someone who's as poor as the proverbial church mouse. And in those circumstances, the impoverished claimant may have some means which may actually amount to a costs award in his favour, but not much else. And so the tribunal might exercise its discretion to say, well, we will make a costs award, a token costs award, because the respondent is the winning party. So at stage one, as my lady puts it, they decide whether to make a costs order. They say, we'll make it, but having regard to the paying party's ability to pay, we know they're not going to be able to pay £100,000, so we'll make the order for a much smaller sum. I don't see how that does violence to the language of the statute at all, of the rules at all.
I have to accept that that would be correct if the amount that is ordered is £20,000 or less. If the
Well, all right, let's say that he's limited means when he's got 30,000 or 40,000. Same applies.
Well, lady, if the tribunal made an order for costs but capped it at £30,000, and the costs incurred were say £50,000 or £100, the question then is the tribunal entitled to impose that cap under 78(1)(b.
He's entitled to impose that cap under 84.
Well, my lady, is that correct? Because we say that what that provides is that in deciding, and I leave out the whether to make a costs order, but in deciding if so, in what amount,
Yes.
the tribunal may have regard to the paying parties or where waste of cost orders made the representative's ability to pay. But when you go back to 78(1)(b, what it provides is that the tribunal may order the paying party to pay the whole or a specified part, so the tribunal can rule on what part of the proceeding should be paid.
Well, is it just the part of the proceedings?
It's a specified part of the costs.
Why isn't it a specified part of the cost, as my lady puts it? Why can't you simply say, well, I'll order 25% of the assessed costs or 10% of the assessed costs, which might be more than £20,000?
Well, lady, that would be potentially a different approach because
Still a cap.
well,
Financially, it's still a cap because you get your assessment at £100,000, but you only actually get 50 because the tribunal has said you can't recover more than half.
well, on the face of it, if that was the approach that was adopted, it would fly in the face of the provision that it's with the amount to be determined by the assessor. The assessor is determining the amount of costs that are to be paid.
We've got that point, but can we focus on the word specified part? The whole of is obvious. Specified part could be a percentage.
Well, certainly on the basis of the Swissport case, that seems to be an approach that could be adopted. I have to accept.
Half the total bill of costs as assessed by a cost judge or an employment judge. So that's all right. Issue specific is all right, isn't it? The costs incurred by the respondent employers in respect of that hearing or that exercise or whatever, that's all right. Half the costs incurred by the respondents in relation to the Auerbach hearing or whatever it is, that would be all right. But you say it's not all right to say the costs incurred by the respondents in relation to the Auerbach hearing or whatever as assessed in detail but subject to a maximum of £85,000.
Oh yes, it's the subject to a maximum of subject to a cap that we object to and say that that's not what the rule provides. And
can we look at the tribunal, the Taylor Tribunal judgment, paragraph 32 and 35, give an alternative basis for or a second reason for their decision, which is they're saying, as it seems to me, we think that apart from the tribunal award which is coming his way, we think it likely that Dr. Tarkait has very limited financial resources. So, taking account of his limited financial resources, we are entitled to use our Rule 84 power to limit the total amount. And effectively they limit it to 84 or £85,000. I appreciate what Mr. Justice Kerr said about not an exact amount, but it's pretty nearly an exact amount. But do you say that that's an impermissible reason for making the order, which they did?
My Lord, I do, and my Lord, if one goes back to 84, the way it's drafted, first of all, if a decision is made to make a costs order, then, if so, in what amount, the tribunal may have regard to the paying parties' ability to pay. And we say that that simply can't suborn the power in 78(1)(b) of the assessor, because it's the assessor to decide what is reasonable. And if, for example...
Sorry to interrupt you, Mr. Duggan, but isn't there an easier way for you to put this? If so, in what amount the tribunal? That assumes that the tribunal is deciding what amount. If you go back to 78(1)(b), the amount to be being determined is not being determined by the tribunal, it's being determined by somebody else, either a county court judge or the employment judge. Therefore, you say, in what amount is not something which is within the remit of 1B.
My lady, yes, and in fact that was precisely what I was about to say by way of an example. If the Taylor Tribunal had said, we consider the cost should be £30,000, because we don't think that the claimant can afford more than that, that would be contrary to the provision of 78(1)(b), because it's for the assessor to decide what the costs are.
Yes, but the assessor can't take means into account. It's very striking. Looking at Civil Procedure Rule 44.4, matters to be taken into account in deciding amount of costs. You can take pretty well anything into account except the paying party's means, which is not on the long list. So if you're right, then means can be taken into account to make an award of £20,000 or less. But once it goes over £20,000, no one can take means into account.
Well, Lord, the question then is whether, if the assessment was simply sent to an employment judge, the employment judge could take means into account under 84, applying CPR provisions, but also because 84 provides that the tribunal may have paying parties' ability to pay, the employment judge on the face of it could say that regulation, Rule 84 applies in carrying out the assessment so that I can take that into account. But I accept that if the matter is sent to the county court, then that can't happen. Any costs assessor in the county court could not do that. And it may be that that is something that was not thought through when the rules were drafted. Certainly the provision that adds the power of the employment judge in terms of assessing was in the more recent regulations, not in the previous ones. But it appears it hasn't been fully thought through, but that doesn't, in my submission, negate the way that this regulation has to be interpreted.
Right. Well, thank you. As you say, it's a short point. It's a rather an important one. Is there anything that we should look at which we haven't looked at so far?
Well, my Lord, there are just two further points that if I could make very quickly.
Yes.
Because your Lordship has two authorities, the Swissport case and the Gilly case. So far as the Gilly and Birmingham case is concerned, all I say about this is that on the face of it, His Honour Judge Richardson made comments which are the same or similar to Mr Justice Kerr's comments in the judgment before you. But it doesn't appear that it was argued. He seems to have made those comments per incuriam without any debate. So in any event, it's an Employment Appeal Tribunal decision which you can depart from.
A
And
very
then so far as
experienced judge of the employment.
I'm sorry, my lady.
A very experienced judge
Oh,
of
my lady,
the
I
employment.
entirely accept that. A judge I've appeared in front of many times, and I would hesitate to make such a submission if it was not for the fact that on the face of it, it appears to have been a comment as opposed to something that was argued before the learned judge. And then in relation to the Swissport case, the Swissport case in our submission is a completely different situation, because it's a case where the lawyers in question were on a damage-based agreement whereby they would get 10% of any damages that were awarded, any compensation that was awarded. And the tribunal imposed that 10% cap, but in our submission, that would have been imposed no matter what, because a party can't recover more costs than they have incurred to their solicitors or their lawyers. Therefore, the indemnity principle would have applied come what may, and it just happened that it was 10% as opposed to up to 35% that could have been agreed under the damages-based agreement. So, in our submission, although Mr. Justice Kerr was correct to draw my attention, and I apologise that I had not taken this case on board, we say for the reasons that it was to do with the indemnity, it's not relevant to...
But what was the jurisdiction?
Well, lady, the thing about the Swissport case is that if I have agreed as...
No, I understand your point. I'm just asking you, what was the jurisdiction for the tribunal to make that, to impose that cap?
I see what... No, lady.
Was it Rule 78(1)(b)?
Lady, yes, it's set out. The Rule 78 was referred to in the judgment.
So 78(1)(b) was wide enough to enable the tribunal to specify a percentage limit on costs to reflect the indemnity principle.
Yes.
That didn't suborn the assessor's function.
My lady, no, because all that the tribunal was in effect saying is that you are only entitled to recover the costs that you actually incur, and the mechanism by which you recovered those costs, by which the party recovered the costs in this case, was 10% of whatever compensation was awarded.
But do you say, had it not been for the indemnity principle, had the tribunal simply said, we think because of the limited means of this particular paying party, only 10% of whatever the total costs awarded are should be paid under 78(1)(b)? We can't specify what that will be. That's for the assessor to determine, but it should only be 10%. Do you say that would have been impermissible?
My lady, yes, because what the tribunal would have said was that only 10% of the amount that the claimants recover by way of compensation should be awarded. Because the tribunal...
No, I'm putting to you a hypothetical. Are you saying that in Swissport, if the 10% had been fixed by reference to ability to pay rather than the indemnity principle, that would have been impermissible?
My lady, yes.
You are.
On the wording of the rule, we say it would have been impermissible.
Because my lord put to you a little earlier that would it have been okay to order a percentage, and you answered Swissport says yes, but you didn't say that was impermissible, but you are saying it's impermissible.
Well, my lady, if the 10% was simply awarded on the basis that of means to pay, we would say it's impermissible. Okay. If a tribunal had took the view that 50% of the cost should be awarded to a particular party because, for example, the way the case was run, that would be a different matter. And that's where what I had in mind when I agreed that a tribunal could make a percentage award. And we quite often see the courts and tribunals saying that the particular party is only entitled to 50% of their costs because of the way that they have conducted themselves or other matters. I would accept that that falls within 78(1)(b as being permissible. What I say is that the tribunal can't place a cap simply because it takes the view that the costs were disproportionate, which is what Employment Judge Taylor did, or because of means. That's something that the assessor has to look at and can in the tribunal, but not the county court.
But
And I entirely accept
would sorry to interrupt, Mr. Douglas. Would it be impermissible for a tribunal to make an order for a specified part of costs and in, say, 50%, and to say 50% rather than 100% because of the ability of the paying party to pay? On a natural construction of Rule 84, it does apply to both 71A and 71B, unless one was going to take a microscope to it and say you can only take ability to pay into account when ordering an amount rather than a specified part, but that would be somewhat crazy, it seems to me.
Well, my lord, that would probably work because 78(1)(b) provides that the order the paying party to pay the whole or a specified part of the costs. So on the face of it, there would be no reason why it couldn't be said that the specified part of the cost would be 50% the costs of the strikeout, for example.
Well, forget strikeout, you're introducing something else. Are you accepting specified part could be 50% of the costs?
Lady, I think that must be so.
That, but my last question was, in clearly, specified part can be a percentage of the total, but in fixing that percentage, can the tribunal take account of the paying party's ability to pay?
My lord, I would say no.
You would say no. So that creates a clear division, if you're right, that ability to pay can be taken account of up to £20,000, but after that, ability to pay is irrelevant as it is under CPR 44.4.
Lord, yes, and I say that's what the wording of the rule provides.
Unless possibly the assessment is going to be carried out by an employment judge.
Yes.
So when it becomes most necessary, because the amount is much greater than £20,000, it becomes a non-factor, a factor that you cannot have regard to.
Lady, I don't seek to defend the illogicality of the rule, but I say that that's what, on the word
Draft. That's true. Yes. Right.
My lord, those are my submissions unless I can assist
Thank
further.
you. Well, thank you very much, Mr. Duggan. You've been very helpful. We won't try to give a response in the next few minutes. We will reserve judgment and hand down, or virtually hand down, a draft in the usual way. You know the form. We'll seek corrections of typos and factual errors, but not re-arguing of the case. And seems to us, so far as the costs of the appeal are concerned, if you lose, then the appeal is dismissed with no order as to costs because Dr. Tarkait hasn't incurred any. If you win, we would invite submissions both from you and from him as to what order.
Well, can I just
follow.
take instructions on that point?
Yes.
Lord, I'm grateful. Lord, I made my submission. I don't propose saying anything further. I'm grateful.
Right. Thank you very much.